So does death make performance impossible? Once we're under contract, are they bound by the contract even in their death? Yes.
Yes.
And that is true for both the buyers and the sellers. So let's talk about how that works, because they're dead. Now, we understood with the seller, right? When the seller dies, there's that asset on the table that is still available to be sold. But how are you going to make a buyer's heirs buy if they don't qualify for the loan, right? Especially if the buyer's heir and a parent is an 8-year-old, they certainly can't make the purchase. The guardian, in the time that it would take to get it done, the contract settlement date would have passed, right? So what is the point of making it binding on the heirs of the buyer? Is this contract contingent on financing? Does the buyer get their money back in North Carolina if their financing doesn't come through? No. Yeah, it is not contingent on financing. So if the buyer's 8-year-old child can't get the loan, what will the buyer's 8-year-old child be in the contract? If the heirs can't get the loan, they'll be in what?
In breach of contract.
Be a breach of contract. What happens to their due diligence fees and their earnest money deposits when they are? That's right, it stays with the seller. So what is the point of making it binding on the buyer's heirs? They don't get to come back for their money. They don't get to come back and say, my mama put down $100,000 in due diligence. She's not here to buy it. I want her $100,000 back. Instead, they have the right and the privilege to go forward with the purchase. But if they can't get it done within the time period of the contract, then they will be out the money that the buyer originally put down. That's what it means to be binding on the heirs of the buyer. It means that the heirs don't get the money back that the original buyer put down. They could go forward with the purchase if they so choose and can meet the contract date, but they don't get the money back if they can't. Now, when we're talking about the seller, what does it mean to be binding on the heirs if the seller dies?
They still have to sell.
Yeah, they still have to sell because this was the last wish of the seller, right? So this one, they obviously meant to do it, as Maria was pointing out. Even if they died before we get to communicate it, it was their last wish. So that's obviously what they wanted to do. They wanted to sell it. And one of the things we're supposed to do is honor the intentions of the people who were passing. So it was their intention to sell, you sell, whether you want to sell it or not. There might be a problem though, right? How long might it take to transfer the ownership from the deceased to the heir? Do you think it might take longer than our closing date allows for in our contract? Yeah.
It can.
So if the buyer doesn't want to wait, the seller will be in breach 7 days following settlement date, which means what will the seller's heirs need to do if they're not going to be able to sell it? What do they have that the original seller collected?
Or due diligence.
The due diligence fee and the earnest money. Exactly. So the due diligence fee comes back out of the seller's heirs' pockets, and the earnest money goes back from the trust account to the buyer if the buyer decides to terminate the contract because it's extended beyond the settlement date. Because the seller is in breach, not able to deliver it in time. But here's the thing. The buyer doesn't have to terminate because the seller can't deliver it in time. If the buyer wants to wait, the buyer has the right to wait. So the buyer can sit there and wait for the legal process to happen so that the seller's heirs have the legal title so that we can close that contract. And if the seller's heirs choose not to, the buyers have the right to pursue additional damages in court much further than the sellers would have breach by buyer. So when we get to the remedies for breach, we're going to see why it's so important that it is binding on the heirs of the seller. Questions on this? So if they die before contract acceptance, no contract. If they die after contract formation, that is binding on the heirs on both sides. That is impossibility of performance, but one that we often get confused with impossibility of performance. And now that there's no pre-licensing test, we don't care about the difference, is operation of law. Operation of law is when the law gets in the way of our contract. For example, we can't sell it if the seller goes into bankruptcy. If the seller's assets get tied up in a bankruptcy proceeding, then we automatically are no longer allowed to sell it. If the bankruptcy court has already got it tied up in their assets, then they have the right to approve the sale. So we could get all the way up to the point and have the bankruptcy court go, yeah, no, we've decided not to let you sell it. And there's nothing we can do if the court says no. So discharge by operation of law comes through if we weren't paying attention to the state of our seller's financial affairs. Make sure if you pick up a listing, you ask if they have been through a bankruptcy proceeding recently and if there is any kind of settlement outstanding or tied to their assets. Because if they're going to have to get approval from a bankruptcy court, that will delay settlement. Statutes of limitations. Contracts time out. They don't go on forever. So at some point, this contract is going to die, and our contract terminates 7 days after settlement if we're not both working diligently toward closing. Eminent domain. Eminent domain says if the government's taking your property, you're not selling it to that guy over there. So if we're in the midst of selling it and eminent domain comes through and says we're buying it, there goes your contract. Any other kind of legal reason we can't sell this is going to be discharged by operation of law. If we had just one spouse selling the property and the other spouse refusing to sell, we're not closing on that property. Discharged by operation of law. The marital rights were not cleared. This makes sense? So anytime law gets in the way of our contract, discharged by operation of law. Anytime it's impossible to perform it as it's written, discharged by impossibility of performance. You don't care why. There's no test question asking you to identify the distinction. All you know is it's dead now. Okay, that's all that matters to us. We're not going to get paid. That's important. So let's go find out what will happen if that's the situation. But first, I've got more to talk about on the way out of contracts. Here's a way you may or may not get out of a contract if you're a buyer or a seller. And that's assignment. Who's heard of wholesaling? You hearing this in the industry right now? No one knows what this is. The Real Estate Commission actually has this in their update this year, which we're all going to have to take since we've now paid our $45 renewal fee. So we've all got to take the update, and we're going to see that they mention wholesaling, and all they do is give 3 different potential definitions for it. And the one that they believe makes the most sense is this concept of assignment. And so we're going to notice that they've actually added the word assignment to the addendum, the agreement to amend the contract. To amend and assign is the way they've renamed it. The reason for this is because we've got some confusion as to how assignment works. So let's just make sure we fully get this. Assignment of contracts is transferring the interests, which is the legal rights to a bond, a mortgage, a lease, a sales contract, transferring the interests to the contract to a new party. It's not changing any other terms of the contract. It's simply changing the parties. When we assign a contract, the contract as it is written stands. The difference is a new party moved in where an old party used to be. And in many cases of contract assignment, this is only a partial release for the original party. In most cases, the original party remains in the background, tied to the deal. Obligated if the new party fails. Obligated to take over if the new party fails to perform. Anybody ever had to do this before? Sublease an apartment? Something like that? It's a terrible feeling. Terrible feeling. Somebody steals your rent money out of your coat pocket, and now you got to break up with them and you can't afford to live there anymore. Wait, that just might have been me. Anyway, besides the point. The point here is I had to go into the office and be like, hey, I can't afford to live here anymore. Can I break my lease? And they're like, no. Well, can I find somebody to live in it? And they're like, sure. Why would they be so happy to let me find somebody else to pay my rent? Because ultimately, if that person fails, I'm still in the background. Why won't they just let me go when the new person comes in?
Contract.
Yeah, there's a contract. How do they know the new person is going to be as reliable and responsible as this person was? And how do they know I'm reliable and responsible? Well, I did show up in the office and ask what I could do. And that puts me above all of those people who disappear in the middle of the night, right? So just by going into that office, I demonstrated I was on the hook. They knew I was coming back to protect my credit and my reputation. They didn't know that about whoever I picked, and they didn't care, because ultimately I was the one responsible. So go ahead, pick anybody I want. It doesn't terminate or change the other terms, and not every contract is assignable. But if there is no clause in the contract that references assignability, then it is. So if there is not a contract clause that denies it, then it is assignable. Unless this is a personal service contract, which means We cannot assign our agency contracts to other agents. Who's the agent in North Carolina again?
Brokerage.
The office, the firm.
That's right, the company, the brokerage, not the agent, not me. So does that mean that once it's inside my firm, any individual representative can be the individual representative? Yeah. That's not assigning the contract. That's just slipping in new representatives. Same contract, all with the same firm. What this means is I can't take my client and send them and force them into a contract with another firm. If I have a client who wants to be exclusively represented on a property listed with my firm, I can't just assign them to another company. I can refer them and take a referral fee. But I can't just force them to go work with another company entirely. Does that make sense? Excellent. Questions?
I have a question, but
Yeah.
can I save it for break? Because I think it's a little off top. It's like strategy with referrals.
Sure, you can do that. You know, I think we're going to have time. So if you want to ask it now, it might be something everybody's curious about.
Okay. Like I said, I'm new. So when you talk about referring people out to the agent you dislike the most or whatever, but like the other day I had a friend that said, my child that lives far away is looking at a house. Well, obviously I'm not the best realtor for them, but how do I go about asking for their business so that I can refer them out and make a little slither without sounding like a creep?
No, you're not a creep. You're going to help them find the best agent in that area. So you can do that going through your company's current referral network,
yes,
or looking outside of it. So if your company already has agents in that area, you can ask for a list of them from your company's referral network and contact them.
Very common. Mm-hmm.
Yeah, just say, hey, I've got this client, they're looking to do this, or I've got a friend who's looking to do this, they want to buy this, and then you can interview them and pick the one you like best, and then go and say, this is the one I think I talked to a bunch of them, this is the one I think that makes the most sense for you. That's not slithery, because you understand more than they do. So
right.
You have a better insight into what makes a better agent than they do.
Do they have to go into agency agreement for me to send the referral, or it's just a verbal, go find me an agent?
Yeah, exactly.
That's it.
That's it.
Okay. That's what that was another part of it, was like, am I putting them into a contract to go send them to somebody else? Okay.
Nope. You're just helping them get into a contract with somebody who can best assist them. But before you do that, you have that referral agreement behind in the back end with your company, so that you're going to get paid no matter what they buy.
Before I send their information over, I send the referral agreement,
That's
I get
right.
the signature, and then I just send the contact information, and that's it.
That's it. And then you are welcome to follow up. As long as they're in state, you can go and participate if they're okay with that. But if they're out of state, you can always call periodically just to check in on the transaction and make sure everything is going okay.
Mm-hmm.
Maria, you've had experience with this?
Yes. And I was thinking about how, if possible, you can also co-broker it, and you guys kind of split the responsibilities. And well, it's just a bigger piece of the pie, that way. And then even when you refer it out, don't be shy about talking about what the referral fee is going to be, because this could be a very big client that you're referring out. And obviously they trust you. So, I mean, how would you feel if someone calls you and gives you, right, a big client, and they want to negotiate the referral fee? You'd be open to that, you'd be open to that depending on, the situation. So yeah, I think it's very common, and obviously we don't want to refer out. We don't have to, right?
Right. But it is always a good idea. And I think, Maria, especially if you are a residential broker and somebody wants a commercial transaction, I would highly recommend seeing if you have any interest in that, being able to co-broker or assist with that.
That is true.
And that may be that will help solidify your position in there to get paid. Because if
That
you're
is
not,
true.
if you're just referring, you may find that commercial somehow forgot your number. So, so make
Yeah.
sure you have that contract. And if your company already has this set up, talk to your BIC if they already have a position or a plan in place for what you should do for referrals. So my company had a referral department, and when it was time for me to make a referral, like for instance, I had an uncle who was coming down from New York who wanted to move to Topsail and build a home out there, which of course, I don't think now he could get insurance, ironically, but at the time he was able to do it. And I'm in Raleigh, but my mom is from Wilmington, and we had lived there when I was younger, and she'd done some real estate there. So I knew she had contacts. So I said, Mom, tell me who we'd want to use in Wilmington. And she found somebody, and they were not in our referral network. So I contacted the company referral network and said, this is the agent I want to refer to. Can we get her in the network? And my company handled it from there. They called me back an hour later and were like, okay, she's in, refer. And so, whatever it is, wherever you're working, check with your BIC first. If there's a protocol to follow that. But if there is no protocol, this is a huge and important reason why you want to attend things like the state realtor events, the National Realtor Association events, attending those things, building networks with brokers from all over and who do all kinds of things. That is super helpful, because that does give you that warm referral you're looking for, when not for your clients, that anybody will be happy to take your friends, your clients, your customers, but for you to know that you're sending them to somebody that you like, respect, and trust.
Mhm.
Yeah. And then of course, follow up behind it, because they sometimes forget there's a referral fee out there. Did that help?
Mhm.
Excellent. All right. What is assignment?
Transferring
Transferring the contract.
contract, yeah.
That's right. Transferring the contract to a new party. Okay. Transferring the rights, not necessarily the
Interest.
responsibilities. Yeah. It is possible to assign the entire responsibility to the new party, but the assignment clause will state that very clearly if there is a transfer of duties as well as rights. Okay. Why does it have to be in writing?
So it'll hold up in court?
So it'll hold up in court. That's right. Statute of frauds says that this is the kind of contract that must be in writing from the beginning, which means that this will be subject to the parole evidence rule. So let's talk about how the judge is going to look at the contracts that you present to them if we ever end up in court. And by you, I mean, this is your transaction file. That's what the attorney is going to take as evidence into that courtroom. So what are we providing to our client to carry into that courtroom as evidence? The first thing that the judge is going to determine is that the entire agreement is in writing. In other words, shh, you don't need to say anything. In fact, we'd prefer you to shh, don't talk, right? We'll ask the questions when you're sitting in the witness box. But right now, shh, we can see what you meant to do because you've given us all the documented proof. Furthermore, they don't look at each document in isolation. They look at the contract as a whole, which means they look at the contract and all associated addenda and amendments. Associated is in the eye of the beholder, and the beholder is the judge. And I don't want to ever get to the point where it is up to the judge to decide if these addenda are actually associated to this contract or not. Therefore, it is my job to make sure that it is clear as crystal what is attached to the contract and what isn't. They give us check boxes inside our offer to purchase and contract, our standard documents, for the addenda that we might want to attach. If we don't check the box beside the addenda, we are giving the judge the right to decide if it exists or not. Anybody want to have their additional provisions addendum potentially ignored by the judge because I didn't check the box beside the additional provisions addendum on the main document? No, I don't want them to ignore all the hard work I did getting my clients' decisions hammered out on paper just to have a judge go, oh, well, there's no checkbox here, so this doesn't count. Make sure you clearly identify what is attached so that they make sure to include it in their interpretation of the contract. The second thing to remember is that words are going to be interpreted by their ordinary meaning unless other intent is clearly noted. If I tell you that my clients want the ice box, which of these is the judge going to think I meant?
The fridge.
The fridge. Because the only people, unless of course the judge is 98 years old, which is always possible, all right? If this judge is 98 years old, they may remember when this is an ice box. Did you know this was an ice box? This is the original refrigerator. The guy, the ice company would come by with a block of ice and you would stick it in one of these holes and that would keep your food cold until the next block of ice was delivered. Ice box. Now it's an antique piece of furniture sitting in the living room holding up the TV. And if that's what you wanted, that's what you should have described. Because if you say ice box, most of us think fridge, if we even think that. Because that is sort of a local colloquialism, right? It's very important that we stay up with the current vocabulary in our local market. Because if we end up in a courtroom, it will go to a court in the county where the property is located. So stick with the vocabulary that is typical in the time and in the place that you are using your contract in. And bless our hearts, we get stuck in vocabulary, right? The older we get, we don't learn the new words, the newfangled language. We just keep saying things are cool and rad and groovy and whatever language it was when we learned it when we were cool and rad and groovy. So it's super important that we stay up to date with the language of our industry. The next thing to remember is that handwritten will override pre-printed. And what we mean by handwritten is anything that augments the standard pre-printed language in the form. So you don't have to print it out and write on it for that to be handwritten. You can pull it up and cross through it using DocuSign or Adobe or Photoshop or whatever program you're utilizing to augment the standard pre-printed agreement. As long as it's not what was standard in there, it will override what was standard boilerplate language. As long as they can understand what the heck it is you're trying to do. Speaking of not being able to understand what you're trying to do, ambiguous terms and ambiguous language and ambiguous completion of documents will be interpreted against the party who wrote it. And what that means is you never want to write anything in here. You want to do your best to write as little as possible in these documents, because the more language you use, the more ambiguous you could be. And the more ambiguous you are, the more harsh the judge will be in their interpretation of it. So, for example, my buyer wants the fridge. If I write my buyer wants the fridge, and both of these refrigerators were on the property at the time of showing, which fridge would the judge award my buyer for my ambiguous writing?
It's his preference, right?
The judge's preference.
Mhm.
And the judge is going to hold it against the person who wrote it. It's not even their preference. The rule says hold it against the one who wrote it. So if I wrote it for my buyer client, what's the most harmful interpretation for my buyer client?
The ugly one.
The ugly fridge. And that's the one the judge is going to award my client, because that's what I asked for. I wasn't clear. If we wanted the fridge in the kitchen, we should have said fridge in kitchen. We could have put the model number. We could have put the serial number. We could have said, see attached photo. But we didn't. All we did was say fridge. Well, that's on us. On the other hand, let's say the listing agent's trying to be slick and they're like, seller's leaving the fridge. If the seller, they say over there, seller's leaving the fridge, and they write in there fridge, and they try to leave us the beat up fridge in the basement, what will the judge give our buyer?
A new fridge.
A new fridge.
Fridge. That's right, because they thought they were being slick over there with their ambiguous language. But in fact, the judge doesn't like that. So the judge is going to be like, oh, you think that's funny? Let me show you why it isn't. Oh, you think you're slick? Oh, you think you covered your client's assets there? Well, you didn't. If you don't write it clearly enough, the judge will hold it against the person who wrote it. And that, my friends, is why we don't write unique language. Because we don't need to. We have closing attorneys. An attorney is right there. Usually they're holding our earnest money for us. We name them as the escrow agent from the beginning. Why are we waiting until closing to contact them when our clients need their help today? My client wants the front door painted red. If I write that into the contract and we show up the day of final inspection and that door is painted red, but it's not the buyer's red, or it's painted red, but it looks like crap. Who did that painting? A 4-year-old? What is that, finger paint? We get into that and the judge is going to be like, well, that's all you asked for. It's red. Shush. Stop bothering me. But if I have an attorney go write it up when the buyer wants the front door painted red, you know what the attorney's going to ask the buyer? Yeah, what color? What's the brand name? What's the shade number? What's the shade name? What finish do you want? How many coats are we talking? When do you expect to have this done by? We want this done by a licensed painter? Are we talking just the front door? I mean, guys, that's the level of detail that attorneys think at. Because attorneys know if it's ambiguous, it's held against them. I'm not writing into a contract an entire sentence. If we get to the point where I need to put a verb in there, we are getting to the point where we need an attorney, or we're handing it over to the buyer and seller and letting them write it in there themselves, with the strenuous recommendation that they have an attorney review it before they hand that over. Everybody good with that? I'm going to hammer that. I'm going to hit that nail until it's so buried deep in the ground. You're going to be like, could you please stop? And I'm going to be like, no, because we don't ever want to find ourselves in trouble in a courtroom for drafting unique language and having that held against our client because we didn't think any better. All right, let's do some questions. Let's see what we've learned. Any questions so far on any of the things we have discussed in basic contract law concepts?
Quick question. If the seller wants to take the refrigerator, they'll put that in the contract, right?
That's a great question, Calandra. The refrigerator, we're going to get into that contract soon, hopefully today, and we'll look and see what is and is not mentioned as a fixture. But you will notice that in North Carolina, one thing that is absent is the refrigerator.
Refrigerators, yeah. I see that a lot.
Yes. So my recommendation is always address the refrigerator. Because it is not addressed, address it. Whether they want it or not, just address it.
Mhm.
And that goes for the washer and dryer too. And the pool table and the hot tub. No, I'm kidding. The hot tub is already in there. It's staying. Alrighty, over the phone, Levon and Mark agree to work together to repair Levon's deck on Saturday. Saturday arrives and Mark is nowhere to be found. Is this an enforceable contract?
Yes.
Yes.
We got 2 yeses.
Yes.
Rama, what do you think?
It's not in writing.
It's not in writing, but it's not a transfer of interest in real property, so it doesn't follow with the essential elements.
No,
Why not?
because it doesn't follow with the essential elements.
No, I mean that's it's not in writing. It's not required as an essential element.
Oh, okay. I was like, I follow with what you're trying to throw out there.
I'm with you there, Rama. But what are the essential elements?
They agreed.
They agreed, mutual assent.
Mm-hmm.
Doesn't mention money.
It makes no
No
mention
consideration.
of consideration.
Yeah, there's nothing for the other guy.
That's right. So is this a valid enforceable contract?
No.
No, this
No.
is a favor. And you know
Right,
what
it's not like the
judges don't,
brothers.
that's right. Judges don't care about favors. Somebody doesn't show up to do something and there's nothing of value on the line. Who cares? This is why every contract has to have something of value, even if it's just $1, right? That is what makes it enforceable in a courtroom. Got to have something of value on the line. So I ask you, if this were not a deck, but the retaining wall that forms a cross easement on their property,
Mhm.
and Mark doesn't show up, now are we under contract? If we've got a retaining wall that's a cross easement on the property,
Yes, there's something for both parties.
yes. And what's the thing of value on the line?
The retaining wall.
The wall.
Their property
easement.
value, right?
Right.
It is shored up by that wall. That's right. If that wall falls apart, then part of Levon's property is going to be on Mark's property, which is going to make it harder for Levon to sell his property and harder for Mark to sell his. So it is in their best interest and therefore valuable consideration in this case. If it were the retaining wall between them, there would be something of value on the line. Remember, It doesn't have to be valuable to others, just to the parties in the contract. Joe tells Bill that if Bill ever sells his hunting property, Joe wants to be the first to make an offer. Bill says for $50, Joe can have the right. Joe pulls out his phone and PayPals $50 to Bill with a memo that says, for the right to make the first offer on your hunting grounds. Is this a contract?
Yes.
Yes.
Is it unilateral or bilateral?
Bilateral.
I got bilateral from Maria.
Mhm.
Rahama says unilateral. Kalandra's like that.
Um,
You don't know. It could go either way.
I think it's unilateral.
What are the promises?
I think it's both, right? Because between them, it's bilateral. And then when Bill does
Remember,
Both.
bilateral means later,
later.
right? So two people promise to do something later. What are the
Mhm.
promises to do something later?
To give you first rights to make the offer.
One person has given us the first right to make the offer. What about this person over here? Do they have to do anything?
Yeah, I have to give you, well, I already gave you $50 for that
That's
right.
right.
Mhm.
So do I have to do anything later?
Yeah, you have to give them the rights.
No. That's this person over here.
He finished his part of the deal. It's only a one-sided deal.
That's right. We have a unilateral contract because Bill is the only one who's made a promise to do something later. And that is, if Bill ever sells, he will have to give that right to Joe. But Joe doesn't have, that's right, Maria, he doesn't have to do anything later because he already gave the consideration today. That's right. Remember, don't get that consideration confused with the promise to do something later. Consideration is what makes it a contract. The promise is what makes it lateral. To promise to do something later. So it's unilateral because only Bill is made a promise. If by the time Bill, and does Bill ever have to sell his property?
No.
No, that's right, no. But if he does, he has to give Joe the right to make the purchase. Now, if Joe has gone full vegan by the time Bill wants to sell, does Joe have to make an offer on that hunting property? No,
No.
that's right. There is no promise that Joe will ever do anything. It's just Bill who promised. Everybody good with that? Awesome. Is this compliant with statute of frauds?
Well, it's not signed.
Good job. This is not signed. If we had only the pre-licensing definition for statute of frauds requirements, it has to be in writing. We would think this is good because it says on the memo for the hunting grounds, but it has to be signed. That's right. Now, if this were not a PayPal, but a check, would that meet the requirements of statute of frauds?
I would say yes, because a check has a signature.
That's right. And once it's deposited, it's going to be signed by the other party too. Exactly. So if this were transferred by check and they had put their signatures on it and deposited it, this meets the requirements of statute of frauds. The judge will hear about this. Impressive, huh? Well, Candace and Paul are out drinking. Candace agrees to sell Paul her jet ski for a slightly reduced price. To seal the deal, they write up the agreement on a cocktail napkin and both of them sign it. The next day, Paul produces the money and Candace hands over the keys. As Paul is preparing for his first ride, the motor falls out of the back of the jet ski. Is this a valid and enforceable contract?
One could say no because they were out drinking and they're probably not very sober when
Ah,
Paul made that decision to buy.
there you go. So we've got the potential of this being what kind of contract based on their capacity?
Voidable?
Voidable. Now, what would make it valid? What do they have to do to make it valid?
Agree? I mean, I don't know.
Agree when they're what?
Sober.
Sober. Sober up
Compensate.
and go forward with the transaction. So the question here is, were they sober in the morning?
Hopefully.
Right?
Mhm.
Because
Yeah,
if
because
they
the next-
were, that's right. If they were sober in the morning, then they made that a valid contract by being sober and moving forward with it. But if we are assuming that they are sober in the morning, we may have a misunderstanding of how alcohol works. Now, I'm not saying I was ever in an alcohol and drug class, but if I were, I would let you know that half of the people in that room with me had been picked up in the morning. The majority of drunk driving tickets, maybe not the majority, but a large percentage of them happen in the morning. Do not assume that because it is the next day, that means they are sober. So schedule it a little later in the day. Remind them, don't sign this, don't perform until you're in your right mind and at full capacity. I always like to say to them, don't take the drugs you're not supposed to, and do take the ones you are, and then sign this for me, please. Okay, because we need them to have that capacity, and we can't guarantee by time of day that they have it. Do you think that Candace was committing fraud here? Do you think Candace knew this was going to happen, Maria?
Well, the motor fall out of the back of the jet ski. I mean, yeah, she knew that it wasn't 100%.
It feels like she got him liquored up and then sold him a bad jet ski, doesn't it?
Right.
Yeah. Yeah. So here's what I want us to remember. We have to assume the best of people because messed up things are going to happen in real estate. And we need the benefit of the doubt, and we need to give each other the benefit of the doubt. One of the first things buyers need to understand when buying property for the first time is that this inspection is good for how long, everybody? When we do an inspection, a property inspection, how long is that good for?
It's expired after
year?
it's done.
It's
Like when
done it's done the day it's done. It's
Yep.
only saying these things are in this condition today.
And
There
they have
is-
they have a hard time understanding when they've been in a property 6 months and something breaks that they had a good inspection or a valid inspection.
Yes, exactly. And they have a tendency to think that it must be our fault, that we did that to them, that we hid something from them, that we were in cahoots with somebody, because things fall apart and it wasn't supposed to happen that way. So here's what I always do at the end of a good inspection. Are you ready? I turn to the buyers and I go, awesome. What do you think will break first? And then I always bet them it's the dishwasher. I bet it's the dishwasher. Because it's important to me that they understand that just because it works today does not mean it will work when they move in. And that I had nothing to do with it. So I make a joke out of it when it's still funny. And then when they move in and 4 months later, they call me and they go, it wasn't the dishwasher, it was the water heater. We can still laugh instead of being furious at me. But we have to set up that expectation that we don't know what's going to happen in the future, and we're not trying to harm them. When it comes to Candace here, We don't know if that jet ski hasn't been sitting in her garage ever since that messy divorce from her husband. And this is the thing that she got in the settlement, his favorite thing in the whole world. And she's been letting it sit and rot in the garage ever since there. Just because she knows it makes him sad. But now she's decided to get over it and get on with her life. So she's selling it to Paul, and she doesn't know that all of the gaskets have dry rotted. She doesn't know that as soon as Paul puts it in the water, all of those things that have dry rotted are going to fall apart, and there goes the motor. So we cannot assume that just because something goes bad immediately after the contract is formed, that must have been some sort of fraudulent or intentional misrepresentation or omission. It could just be Murphy's Law. Rahama?
Silly story. You know how married couples are told to kind of have like a limit, like when you spend so much, if you go over this limit, you should call your spouse before you spend it. My husband and I didn't know that rule, and he inherited a jet ski. And since the topic is jet ski, he took it out on the reservoir. It broke down. He took it to a repair person and put a ton of money in a jet ski that never worked. And so then we learned that rule about having our limits and that we talk to each other about. So, yep, that's my funny jet ski story.
I feel you, Rahama.
Mhm.
My brother and his wife learned that limit when their dog ate a rock.
Oh.
$11,000 later,
Oh.
Ooh,
twice.
ouch. Twice.
Twice.
No.
Because they
Why
got
rocks?
home and he immediately went back out into the yard and ate another rock.
Did again.
Dog
That's
was
Maybe
not
too
a
she's
stupid
really
to
smart-
live.
hungry.
Not a smart dog.
He's not a smart dog. I'm telling you, that was Murphy's Law. Not Murphy's Law. That's what's the one? Darwin's. That was
Darwin.
Darwinian there.
Mhm.
Alrighty, one more. Bill knew that his wife was planning to leave him, so he held a gun to her head and told her to sign away all her rights to their children and their property. Fearing for her life, she signed the contract that Bill had printed from LegalZoom. Does Bill's wife, thank you, I think that's funny too. Does Bill's wife have any recourse?
Yes.
Absolutely.
Absolutely. What can she claim?
Under duress.
Under duress. My question is, when can she reclaim it?
When she gets away from the gun?
And 30 days.
Is it just the gun?
When
The
she gets
husband.
away from
Yeah.
the husband?
Yeah.
She was
And that's,
fearing for her life. Yeah,
yes.
so-
And that fear doesn't go away just because the gun's been removed. And that's
Right.
something to keep in mind with domestic disputes. When you're looking at a couple, if you get the distinct impression that you don't have all of them on board, talk to an attorney. Have them talk to an attorney. Really insist that they talk to an attorney. Make sure you have all sorts of documentation in your files that indicates that you made every effort to get them to an attorney to confirm that this was something everybody wanted to be a part of. Okay. Just make sure everybody's on board, that this is something everybody wants to be a part of, that we have mutual assent and reality of consent.
Catherine, have you ever had a showing or a listing where the wife is yes, the husband's no, and it's just always like no one can agree on anything? Like, what do you do in that case? Because it can be somewhat annoying, but you want to get the sale, but
Yeah. Yeah. Anybody want to chime in on that? Maria or Rahama, anything you want to say about this?
I had a recent situation where the wife is an interior designer and he's an engineer builder, and they were selling their house, and it was her baby. This is what she wanted. This is her dream home. And there was an illness. There is an illness, and it was him. He was sick, and I think he was just trying to kind of protect the family, consolidate, and go smaller to a condo. I mean, by the beach, beautiful, but she wasn't very cooperative, and you could tell. And but she did say, we wanna list it, and this is what we want, and unless we get that, we're not selling, that kind of attitude. So, and then she wouldn't give me access to show the property,
Yeah.
like just made it very
Yeah.
difficult. And of course, now you're thinking it's going to look like I'm not doing my job, right?
Yeah.
It's going to look like I'm not fulfilling my promise. And it was very hard. And I think that in this situation, there were a couple opportunities where I kind of had a chance to pull her aside. She introduced me to her sister. So I had some time, some girl time, and I just kind of felt for her. And I said, this has to be so hard,
Yeah.
you're, and just kind of walked that and
Yeah.
I mean, she realized that they needed to do this, but I think just not being too cold, not transactional about it. And there's just, people are so complex. There's so many different reasons why people experience change and how they respond to it. And it might be like, we got to get this on the market and, or, that kind of thing. I did tell her once, she says, well, as soon as that offer comes in, and I did say, I just really need access to your property because how he only gave me this much amount of, and I need some access to it. She wouldn't let me do an open house because she didn't want people touching her stuff. And it was just very hard, very hard. But
Yeah.
I think just include the human part of it and stay away from transactional where it's just, especially with her. With him, I had a different attitude. So you have
Yeah.
to kind of learn your sides. Yeah.
I think underscoring that, Maria, the point that Maria is making is that there was one person who didn't want to be in that transaction as much as the other. And I
That's
think
right.
that's what you're seeing there, Calandra, when you've got that opposing viewpoints, you've got somebody in that who doesn't really want to be in it right now. There's something in there that is holding them back, and they're using these details in the property as excuses to avoid moving forward. So you want to kind of get a hold of whichever one is obstructing and just sort of get in there and feel around, ask some questions about, how do they feel about finances? Are they, and then make sure, because I'm guessing financial issues is the concern here. There's that fear of that, what is going to happen when I own it and how will I cover these expenses? And this is a big decision. Maybe they need a little more counseling from a lender. Maybe they need first-time buyer class. Maybe, there are things out there that you can do to support that buyer so that they feel more confident in the purchase. And the more confident they feel, the more willing they will be to work with you and their spouse or the other buyer. So if you see that conflict between them, that's an indication usually that there is a deeper conflict between them. Right? If it's just an issue of financing, we can fix that. If this is an issue of the two of them, then that's a relationship counselor that needs to be involved. In which case, figure out which one is going on the mortgage and just focus on that person. Because ultimately they'll be the decision maker. And if this relationship falls apart, they'll be the one who stays behind.
Good advice. Thank you.
Yep. Excellent. Any other questions, comments, or concerns about all of this? That was very helpful, Maria. That was excellent advice. Excellent advice from somebody who's been doing this. Yes. We always appreciate that. All right, let's talk about, well, let me rephrase. When we're going to come back from our break, we're going to talk about remedies for breach of contract. So we're going to talk about what happens, what the recourse is. Since break isn't for another 4 minutes, though, I'll go ahead and get us started on this process by just sort of giving you an outline of what the recourse is in North Carolina, depending on who the party is. If the buyer is the one who breaches a buyer contract, an offer to purchase and contract, the seller's recourse is the earnest money. If the breach was by the seller, then the buyer can take them to court. There's the potential for mediation. If it is by the tenant, and then there's also cancellation of the contract, which I should have in there. If this is breached by a tenant, then the landlord can always go and take compensation from the security deposit. If this is breached by a landlord, then the only recourse the tenant has is to constructively evict themselves and or pursue damages in court. And if this is a breach of our agent principal relationship, then the first thing we're going to do, according to our standard forms, is seek mediation. And if that is not successful, we can always pursue our rights in court. Take note, if you're a property owner, there is money there for you, all ready to go in the case of breach. But if you're not a property owner, then there is a court date that you can set. One of these just gives money to somebody, and the other one is going to cost somebody some money to get. So, just pointing this out there. It's always easier to be a property owner in North Carolina. But the thing that is to remember here is that at least when it comes to buyer and seller, when you're the seller, you better know what it's about, what breach means before you get there. Or you may be very disappointed in the results of that breach. So when we come back from our break, we're going to talk about what liquidated damages mean and how that applies to the earnest money and how that limits the rights of the seller. But first, we're going to take our break. So I'll see you back here at 10:20 for the next 70 minutes of excitement. Now, remember to come back on time, because if you don't, I'll just be here by myself and I will sing to you again. I think it should be illegal to have the BG stuck in your head. Like, I think there should be a law on that. Of course, I did try to do that to all of you, so. All righty, everybody. It is time to come back to the computer machine. If you haven't already, thank you, Calendar. Remember to chat something in the box to let me know you have returned from the Great Backup Beyond on time. Thank you. Excellent. All righty, we're picking up right where we left off, talking about what happens when a buyer breaches the contract between the buyer and the seller. What we have is liquidated damages. Liquidated damages is money for your trouble. And by your trouble, I mean the sellers. So liquidated damages is all the seller is going to get in the instance of buyer breach. Now I've got residential resale, but it's true for all forms of buyer breach. If the buyer walks away, then the seller gets the money that was already put into a deposit in a trust account that was supposed to be there as proof that they were serious about the transaction. It's the earnest money. Across the country, it's the earnest money. And in North Carolina, it's still just the earnest money. You will see in our contract that we identify the due diligence fee as well as something that the seller gets to keep in the event of residential buyer breach. But it's important to remember that that is not compensation for the breach. The due diligence fee is the compensation paid to the seller for the right to walk away during the due diligence period for any reason or no reason at all. It is the seller's to keep and only appears as a credit back to the buyer on the settlement statement. So the seller keeps that in the event of buyer breach, but that is not considered their compensation for the breach. The actual compensation for the breach is the liquidated damages of earnest money and additional earnest money deposits. Okay, these are going to be, this is what they get. And this is it. This is all. If the buyer walks away 2 days before settlement, that's all the seller has the right to. If the buyer has done no damage to the property, then the seller cannot pursue additional money in court. This is why it's very important that we explain to sellers when it comes to how much earnest money do you want? The answer should be, I don't know. How much will it take to keep you from hating me if the buyer backs out the day before closing? Whatever that number is, double it. If we're using the standard agency agreements, our standard agency agreements are giving our company the right to keep half of that earnest money as our compensation for that transaction. So if that is what our company is planning to do, we need to make sure that the seller understands that. Because if they need $1,500 to pay their bills for the 6 weeks that we've been under contract, and they only took $1,500 in earnest money, $750 of that is coming to our company. They're going to be disappointed that they don't have enough to compensate for the time they were under contract. So make sure your seller understands that whatever they think they need for earnest money, we want to aim at double that if our company is planning to split it with them in the event of breach. Questions on that? If the seller breaches, the buyer has all sorts of damages to pursue. If the seller is not able to deliver the clear title we were looking for, or the property in the condition as it was at the time of showing, then the buyer has the right to seek compensatory damages. Give me back all the money that I gave you, and pay for my inspections, and pay for my appraisal fee, and pay for my rate lock. They can even pursue consequential damages, which is there to cover potential losses. Now, I could try to explain it to you, but why when they give us a perfectly good example in the manual? A seller and buyer enter into a valid contract for the seller's home for $395,000. When the seller breaches on December 12th, the property is actually worth not $395,000, but $410,000. Therefore, the buyer's damages are $15,000. If the buyer had to go back out onto that market that day, they wouldn't be able to buy the house that they wanted for $395,000 anymore. It would be priced at $410,000. So the seller owes them the $15,000 of difference in the equity of that property since the time they went under contract. Consequential damages. Oh, yeah. Consequential damages say, if it's worth more now, pay me the difference. And if it's worth less, oh well. So they have the right as buyers to get all of their money back, plus some, if that's what it takes to get back out into the market. It's also a rescission in that case. They want their money back. If we have a breach of contract, that should happen through operation of law, or we may decide we just are going to cancel it, and rescission means putting us back to our original terms, giving us our fees and deposits back. If we don't want to rescind the contract, though, remember, our buyer may be able to pursue the rights of specific performance. Do we remember what specific performance means? What does it mean?
To have to perform, to have to move forward.
Exactly. To specifically perform to the terms of the agreement.
Yeah.
Yep. And this is available when the seller breaches. This is not available when the buyer breaches. This is not available when we have a breach between agent and principal. Well, that actually might be available if we have a breach between agent and principal on the sell side, but on the buy side, definitely not. When the seller, when the property owner breaches the contract, we may be able to force them to perform to the terms of the agreement. And in the case of a buyer and a seller, that means you must sell. When we get to remedies in our contract, we want to pay very careful attention to the way it is written, because what we do at the point of breach may impact our client's ability to move forward in pursuit of additional damages. So keep in mind, when the seller breaches, the buyer has way more rights. Don't cut their nose off to spite their face. Make sure they talk to their attorney before they accept money back or make any decisions about what they want to do. Okay, do not counsel them. Have them talk to an attorney. When the buyer breaches, you can be pretty assured that the only thing that seller's getting is the earnest money that's in the account, and they're only getting half of that. But when the buyer breaches, their options are wide. When the seller breaches, that buyer's options are wide open. So make sure that you give them the opportunity to explore their options. Questions on what happens, remedies that are available for breach. We're going to come back and talk about property management at the end. And we don't discuss breach between agent and client because that's broker relationships and responsibilities. No questions on this section then? All right, it's time for a non sequitur. And that is why I say, here's another specific performance. I am not referring to this as being any kind of specific performance legal thing. I'm joking here. I had somebody go, wait a minute, I don't understand how that relates to specific performance. And I was like, well, because he's performing, because he's got the hat and the gavel and he talks fast, and never mind. So what I mean here is we're going to go talk about auctions now. And this has absolutely nothing to do with any of us. Anybody in here an auctioneer? Now, me either. If you want to be an auctioneer, you need an auctioneer's license in addition to your real estate license. If you want to be this guy, you just need a gavel and a fancy hat, okay? If you want to be the auction crier, no license required. Maybe an auction crier's license. I don't know. I'm not involved in that. So why do we have to talk about it? Because the commission says so. So let's talk about what the commission says we need to know about auctions for this course. The most important thing to remember is that auctions can be performed with reserves or they can be performed without reserves. If you are working with a buyer client and they want to purchase a property at auction and they are asking for your assistance, part of your job is to find out, are there reserves? And if there are, what are the guidelines for rejection? Because if there are reserves, then that means that the person who is selling the property has the right to reject the winning bid for any reason, unless there are guidelines set. So they could get to $20,000 over whatever we thought we were going to get, and the winning bid could still be rejected by the seller because the seller doesn't like what the buyer is wearing today. Wouldn't that irritate you? What do you mean you're not selling? I'm not selling. Why aren't you selling? Do you see what he's wearing? That person isn't going to own my house. I won't have it. With reserves without guidelines means any reason at all. But with guidelines means there are only specific reasons why the seller can reject the winning bid. What is the most likely reason that a seller will reject a winning bid at auction? Anybody want to take a guess?
Not high enough.
Not high enough. That's the typical guideline set around reserves, that the only reason it will be rejected is if it does not reach a bottom amount. Okay, if it does not reach the floor. And that is how these work. Anybody ever watch Texas Flip and Move? Have you ever seen this show? This was a fascinating show on the Learning Channel. You really can learn all kinds of things on the Learning Channel, but only in small doses. I'm making a joke on the Learning Channel. I'm just sorry, but okay. Anyway, the Texas Flip and Move was the most fascinating show because in Texas, what they did when they rehabbed a house was they lifted it, carried it on the back of a truck to a auction lot where they would rehab the house, sell the improvement, and then the buyer would put it on the back of a truck and take it to their land. And it was the craziest thing I've ever seen. These two ladies right here, they would sell their properties for like $35,000. They were looking to make $2,000-$3,000 for their labor. It was insane to me. That was their profit margin. I'm like, okay, whatever. But since they had such a really small profit margin, what that meant was they set reserves. If it didn't come in at 34,000, they wouldn't sell it. If it sold at auction for 33,500 and they set the baseline at 34,000, they're still going to slap the gavel at 33,500 and say sold. But at the end of the auction, that guy in the fancy hat is going to come back to the two ladies and go, ladies, the top bid was 33,500 and you wanted 34. What do you want to do? And those ladies at that point have the option to go, we'll take it. And if they say we'll take it, then that buyer bought it. But if they go, that's not enough, then that buyer is not getting their house today. That's how reserves work. It gives the seller the right to decide if they want it or not, even though it didn't come in at the bottom dollar they claimed they were expecting. It gives them the opportunity to realize what really is their floor when the rubber and the road meet. Without reserves is how this guy in his overalls would always do it. He just flew by the seat of his pants. He would get out there and he'd say, let's see what we can get for it. Without reserves means if there are 5 people in the lot that day and they don't get up to 45,000, which is what he had invested in it, then he's going to take a loss. And if they get up over 45,000, then he's going to win. And that's all I got to tell you about auctions.